You're with Dr. Nita Chhinzer, and today we're talking about who's legally defined as an employee in Canada. In the past few decades, there's been an increase in non-standard work. Sometimes this is referred to as alternative work arrangements. This can include on-call workers, like IT support technicians, agency workers, like temporary or legal help leased via an agency, direct contract workers. This includes freelancers, independent contractors, and day laborers. It also includes gig workers, like those who work for Uber and Upwork. In fact, the number of contract and self-employed persons in Canada is growing. Statistics Canada shows over 2 million people in Canada work in some form of temporary employment in 2023. That includes seasonal jobs, term or contract jobs, casual jobs, or other types of employment. Moreover, there's many self-employed people working in Canada. According to data from the 2021 census, roughly 1 in every 8 persons in Canada are self-employed. An employer might mistakenly perceive that they have lesser obligations to these non-standard workers. For example, less obligations for severance pay if terminated or the right to overtime pay. But legally, the Government of Canada indicates that employment status is determined by the nature of the working relationship, not based on how people are paid. When determining whether a relationship is an employer-employee relationship, there are 6 factors to consider. These factors are not prioritized or weighted, but rather they're assessed collectively to ascertain the nature of the relationship. The first is control. Who has control over how and what work is done? For example, does the company or the individual have control over the amount of pay, the performance standard, the work completed, or the training provided? If the employer has control, then this is likely going to be perceived as an employer-employee relationship. The second is tools and equipment. Whichever party owns and maintains the tools is likely the party that is perceived to have power in the relationship. Third is subcontracting. Can the individual hire workers directly or subcontract work to others? If so, they are likely self-employed and not an employee. The fourth is financial risk. Are there fixed, ongoing costs that the individual bears for which they are not reimbursed? If so, then they are likely considered self-employed. The fifth is investment and management. Who's responsible for making decisions that affect profit and loss? If the employee makes no capital investment in the payer's business and has no rights to hire staff or individuals under their own business, then they're likely an employee. The sixth is opportunity for profit. Do they have benefits like pensions or health insurance provided by the company? This would likely indicate an employer-employee relationship. Therefore, employers in Canada, whether a small business or large corporation, must be aware of the interpretation of employment in Canada to determine what their obligations are towards the worker. This can help avoid lengthy and expensive lawsuits and ensure that both the employee and the employer are aware of their mutual expectations.